Hello, everyone. My name is Ayana Robinson. I am supervising attorney for legal aid of North Carolina's expunction team. I work out of the Central Intake Unit. Thank you for joining us today on our Free Form Friday. Today, I'm interviewing Daniel Bowes, Executive Director of the North Carolina Justice Center, and DJ Dorr, supervising attorney in our Durham office with a focus on expunction relief and driver's license restoration. Today, we're here to talk about the Second Chance Act. June 25th, 2020, just last month, Governor Roy Cooper signed into law the Second Chance Act, which greatly expands expunction opportunities and truly gives North Carolinians the opportunity, a second chance to restore their lives. There are 5 provisions that we're going to talk about today that we're going to focus on. One of them is known as raise the age. The other we'll talk about is dismissals and acquittals. What's really exciting is that there are now 3 categories to the expunction of convictions. There are the expunctions of single misdemeanor charges, multiple misdemeanor charges, and single felony convictions. We'll briefly talk about access to expunged files and limited driving privileges. So let's get at it. Let's talk about raise the age, Daniel and DJ.
Yeah, thanks, Ayana. Always glad to be working with legal aid. Obviously, legal aid attorneys are at the forefront of employment issues around the state, and especially or increasingly expunctions. I will say that you gave me a promotion that I do not have yet, and it would never take. I am not executive director of the Justice Center. I'm the director of the Fair Chance Criminal Justice Project, and obviously, Justice Center has long partnered with legal aid and excited to do so on expunctions. You know, the first part is basically what we're thinking of as raise the age parity. As many of y'all know, there was a 10-year battle that many of y'all were involved in in your personal lives to basically raise the maximum age of juvenile jurisdiction from 15 to 17. And so that went into effect December 1st, 2019. And then the conversation became, well, what about those individuals who were convicted as adults but would now be treated as juveniles if they were charged today? And so expunctions are one way to provide some of that relief. You know, the relief of if you have a juvenile record versus an adult record, a juvenile record, one, you're going to go into the juvenile system, which is much more focused on rehabilitation. We can't mimic that, obviously, because they're already at the system. But what we can do is keep that record confidential and through expunction. And not allow, keep it from coming up every time you apply for a job or apply for housing. And so that was important to do. What we were excited to see was how broad it was. And so basically right now, if you have any misdemeanor or any H or I felony conviction that occurred at age 16 or 17, the offense occurred. It doesn't mean you were convicted when you were 16 or 17. It means the offense occurred when you were 16 or 17, and it resulted in a misdemeanor or felony conviction. It doesn't matter how many of those you have during that period. It doesn't matter whether you have a subsequent conviction. It only matters whether it's an HRI felony conviction or misdemeanor. That's a question about whether you're eligible or not. Now, there are some exceptions. There are 2 big ones. One would be if it's a traffic offense, you know, and whether that's a misdemeanor, you know, speeding offense or a felony fleeing to elude, those are not going to be eligible for expunction under this section. The other thing is anything that ends up putting somebody on the registry, the sex offense registry, whether or not they are currently on it. But besides those 2 categories, traffic offenses and sex offenses that result with registration on the sex offense registry, any misdemeanor or felony or multiple misdemeanors and HRI felonies would be eligible for expunction. You still have to apply for you still have to petition for relief. But also a DA could petition, and that's a sort of a different conversation, but a big evolution in the law. But that's the basic eligibility for it. DJ, do you want to talk about sort of the other criteria, the few criteria? But you know, the last thing I'll say about it is if the person is eligible, the other big change is the judge has to grant it. They don't have discretion here. If they judge that the person is eligible based on the criteria, the statute says they shall grant the expunction.
That's right. Thank you, Daniel. And thank you, Ayana. We're really excited to be able to bring this important information and these important changes in the law to North Carolina's community and to the folks that we we know desperately want this relief and are excited to be able to use it. So when you're looking at the raise the age changes, the big criteria that we want folks to keep in mind are some of the pieces that Daniel's already covered. What is eligible, those class H and I felony convictions, other than the traffic offense and the offenses requiring registration on the sex registry, as well as any misdemeanor convictions. One thing that you do want to keep in mind is that you will have to ensure that you've completed any sentence that was imposed as part of that particular conviction. So we're talking obviously about an active sentence, but also any periods of probation and any post-release supervision that's been ordered. That has to be completed as well. And so it's important that individuals know their status in those particular cases so that they're not finding a delay when they go to seek that relief. But once that sentence has been complied with, there's no additional waiting period. So assuming that somebody has already met that criteria and the terms of their sentence, they should go ahead as the court system has distributed the forms that they can use to petition for that relief. The other big criteria is a filing fee. So if the individual is asking the court to expunge that themselves, there is a $175 filing fee. Although folks need to be aware that if they are unable to afford that cost, they can ask the clerk of court and the court system to waive that fee. And so that's a fairly straightforward process, and we don't want anybody to be dissuaded or frustrated that they can't seek that relief because of that filing fee. There is a filing fee, but again, they can ask that to be waived if they cannot afford it. So don't let that be a barrier to getting these matters expunged.
Thank you. You guys have answered all of my questions. Just to circle back around though, when you say all misdemeanors, you mean violent and nonviolent?
So I will say the exception applies to both felonies and misdemeanors. So the traffic offenses and anything that's on the that results in registration, those are the two exceptions. But everything else, there are no other distinctions between nonviolent and violent. So obviously you could, like assault, simple assault, that's something that you have not generally been able to expunge because it's not a nonviolent offense, but you would be able to expunge if it occurred at age 16 or 17 under this new provision.
Mm-hmm.
And let's say I was 16 or 17 years old and I had a large number of convictions. Is there any limit to how many I can apply for?
No, as long as they are eligible, as we just described, you could have 10, 15 eligible misdemeanor convictions or class HI felonies, and those can all be expunged. There is no limit.
That's excellent. So moving on to dismissals and acquittals, let's discuss those huge changes.
You're gonna take the lead, DJ, and I'll fill in?
Sure. So I think the really exciting change to dismissals and acquittals, and I think it is always worthwhile just to mention when we say charges and convictions in these presentations, when we're talking about dismissals and acquittals, we're talking about situations where you received a charge and typically it's either dismissed or what's typically known as being thrown out by the court or the DA. So it's dismissed by the court, it's dismissed by the DA, or for some other reason the matter was not able to go forward and it's no longer in court, or you were found not guilty. So those would be the acquittals. So typically individuals have been eligible to expunge all dismissed charges and not guilty acquittals as long as they meet one criteria, which is they cannot have any felony convictions anywhere in the United States. We're really excited that that felony prohibition is now gone. So once this law takes effect in December, a person will be able to expunge all of their dismissed charges and any not guilty acquittals, even if they have a felony conviction. So that is a huge change, and it's going to allow many, many more people to remove these non-conviction records from the system.
Yeah. And the one thing I'll say
Now,
about-
let's say I've already had a dismiss. Okay.
Oh, go ahead. No,
Okay.
go ahead.
Now, let's say I've already had a dismissed charge expunged. Can I now come back and have another dismissed charge expunged?
Yes,
Yes.
you can expunge them as much as you want. It is meant, there's a public policy decision now that says that if somebody has a charge dismissed or expunged or they're found not guilty, that they should have a pathway to not have to run into barriers triggered by that dismissal. And so that's why they made expunction so broadly available here. And again, we're not going to go into it in this conversation, but this is another place where DAs newly have the ability to petition for the relief. But, this goes into effect December 1, 2020. And like DJ said, you'll be able to expunge all dismissals at that time and all not guilties prospectively and retroactively. Now, the only thing I would note here also is that when, this could even be people who have serious criminal records. Like, you could have a possession with intent to sell felony conviction that would give you problems, but you could also have from that same incident, a dismissal for false imprisonment, kidnapping. There's a whole bunch of things that have a particular kind of stigma to them. And you could see how, even though possession with intent to sell is a serious felony, that the dismissed charge of kidnapping or some other thing could actually be giving rise to bigger collateral consequences. So that is a relief, the full range of criminal records, that's a big change.
Is there any waiting period?
No.
Is there any fee to file for these types of petitions?
So generally, no, there is no fee. The only exception is if your charges were dismissed pursuant to some sort of deferred prosecution agreement or a conditional discharge, which most folks probably are aware if their charges were dismissed and they had to do something in order for the DA to ultimately dismiss those charges. Those particular types of dismissals do require a $175 filing fee. But again, just like with the raise the age expunctions, if a person cannot afford to pay that, they can petition the court to waive that cost. So again, don't let that be a barrier to seeking your expunction relief.
And these provisions go into effect December 1, 2020, which is a few months away. Now, there's something about automatic expunctions that does not go into effect until December 2021, but let's briefly mention those.
Yeah, well, I mean, the main thing and what legal aid is trying to respond to is what's become known as the second chance gap, right? Like we've over several years expanded eligibility significantly. And this was a especially big leap. But at the end of the day, what the experiences in North Carolina and around the state or around the country are that as anytime it's a petition-based system, you're going to run into access issues. Obviously, I don't need to talk to legal aid about sort of all the barriers to access that people face when they're living in poverty. So that is a particular issue that's problematic. And so we want to continue to expand and still use a petition-based system and where a judge has to use discretion. But as much as possible, we need to move toward automation. And so that's what, at least in the case of charges that are dismissed prospectively, so beginning December 1, 2021, we came up with a process, and I give a lot of credit for AOC to figuring this out, to efficiently in times of staffing, but also just money, expunge those at the time they're dismissed. So you don't require somebody to petition. You're taking care of 100% of those that are eligible. It's by operation of law. And so that's where we were able to sort of get it in this round. I will tell you that is the goal for all expunctions. And that's one of the lessons learned is that you need automation to deal with the second chance gap, because anytime you have petitions, it's not going to work. Now, obviously, a middle response or a halfway addressing this is DA initiated relief, where the DA can say, okay, this person's coming in front of me, I'll expunge the dismissed charge, or I'll look at this entire list of 16 and 17-year-olds who have convictions of misdemeanors, felonies, like we talked about before. That gets toward the second chance gap also. But as much as we can, we do need to move toward expunctions by operation of law. But for now, that is really the only place where it exists. Well, beginning December 1, 2021 is the only place it'll exist, is where charges that are dismissed beginning at that time.
Yes.
Okay.
And let me just make sure that we're clear, just because I don't want there to be any confusion. As Daniel said, it's prospective, and so those are for matters that occurred, after that December 1st, 2021 date. So if you have a dismissed charge that's already been dismissed, take care of that now, because number one, you should go ahead and get it off your record so that you can move on and pursue the things that you want to pursue. But number two, it's not going to automatically come off of your record a year from now. It will still have to be dealt with through the petition process. So again, don't delay. We want you to get the help that you need.
That's an excellent point. So we talked about raise the age, we talked about dismissals, and those are very specific categories. But everyone's super excited about the expunction of convictions. So there are now 3 categories: the expunction of single misdemeanor convictions, multiple misdemeanor, and single felonies. Let's briefly discuss single misdemeanor convictions, which I know hasn't changed, but let's just discuss it and outline the criteria anyway.
Okay, I can cover this from the start. So yes, there's not really much of a change to the single misdemeanor conviction expunctions. And again, this is for, first of all, anybody, regardless of their age, of when the offense occurred. So really the criteria here is that, number one, it cannot be considered a violent offense, and the statute lays out the criteria of what is considered violent and therefore excluded from eligibility. And just so everyone's on the same page, you're generally looking at the Class A through G convictions, all Class A1 misdemeanors, any offense that has assault as an essential element of that offense, impaired driving, so DWI offenses. Those are all, and some others as well, but those are really the big ones that folks are generally asking about. And those are not going to be eligible to be expunged. So assuming that your conviction is not on that list, you are eligible to expunge that single misdemeanor conviction after 5 years. So it's a 5-year waiting period, and it's 5 years from the date of the conviction, but you also must have completed any sort of sentence within that 5-year period. So that's generally how we look at that. So if your conviction occurred in 2010 and you were given a year of probation and you successfully completed that probation in 2011, then you would be eligible, assuming you meet the other criteria, to expunge that single misdemeanor conviction as of 2015. So 5 years will have passed from the date of conviction and you completed your sentence. Now, if for some reason you did not complete your sentence within that 5-year waiting period, then you would need to go ahead and complete that sentence. But once 5 years has run and you've completed the sentence, you'll be able to file for that expunction. So you cannot have any other convictions to seek that expunction of that single misdemeanor conviction. So it's really geared towards an individual who made a mistake and has not had any other conviction related mistakes and is now ready to move on and get it off their record and have a second chance. It is a petition. You do have to file that with the courts. There's some affidavits that are required from both you and 2 witnesses who can attest to your character. There is a filing fee that is required, although again, that is a waivable filing fee. And there is a requirement to serve that on the DA. And so it's a little bit more involved of a process, but it is not a process that should be we don't want people to be discouraged by the process. We want people to still seek it out, but it does require a little bit more work and a little bit more waiting time compared to the other 2 categories that we've just discussed.
And absolutely, in terms of being discouraged, I just want to point out again, legal aid is here to assist in that. Now, to clarify, that is the law right now regarding single misdemeanor conviction expunctions.
Yes.
Moving forward, let's talk about multiple misdemeanor expunctions, which goes into effect December 1, 2020.
Yeah, and that was a really good description, DJ, of the single, a first-time nonviolent misdemeanor. And as Ayanna said, and DJ, that's been preserved, that wait period. Now, all the other sort of issues that that DJ talked about what nonviolent means, that's maintained throughout all these expunction of convictions. It's that was not touched in the law. There was no change there. The only thing I would emphasize about what did change for that first time conviction is that currently, so the law now is that even if the person is eligible, the judge has discretion. What changed is beginning December 1, 2020, if the person is eligible, they will not have discretion, that they have to grant it. And that is also true for the multiple nonviolent misdemeanors after 7 years, that if the person petitions for relief for all of those convictions, that the judge cannot deny it if they've already determined that the person is eligible for it. The only other thing I would say about that is with the multiple convictions, it is, whereas DJ was talking about it being 5 years from the date of conviction, as long as a person has finished their sentence, once that 5-year period has come to pass, the person is eligible. It's different with multiple convictions. Not only is it a 7-year wait period, but what they went in and specifically intended to do was to put that 7-year wait period, if there is no sentence, if there is no probation, and it's 7 years after conviction, but obviously most sentences include probationers, they have sentences. And so they said that it's 7 years after you finish your sentence. And so and that's what it's going to be for 99% of cases. Again, if there is no sentence, then 7 years past the conviction. But that's a big distinction between a first-time misdemeanor, 5 years after conviction, versus multiple misdemeanors, 7 years after sentence completion. And so, yeah, and everything else that DJ said is true about the nonviolence. And the one exception is you can have other convictions as long as they're traffic offenses. So you can have like a misdemeanor speeding offense and still be eligible. That's not going to disqualify you.
Now that's a huge change. So let's go over some scenarios so that everyone is absolutely clear. I have 3 misdemeanor convictions, 2006, 2008, 2010. I've finished all of my probation, parole. I don't owe any funds. Can I get all 3 of them expunged?
Yes, as long as it's been 7 years since you completed the end of your most recent sentence. So if you were convicted in 2010, but you were, again, given a 1-year probation and you completed it in 2011, then your 7 years starts counting from 2011.
Okay. So I have 3 misdemeanor convictions, but the first one in 2006 was for simple assault. Can I still get all 3 of them expunged?
No, and here is one of the tough parts, is that you actually cannot get any of them expunged, because one thing that the DAs negotiated pretty hard as this bill went through the legislature was, in the original version, you wouldn't have been able to expunge the violent misdemeanor, but if the other misdemeanors were otherwise eligible and the wait periods were satisfied, you could expunge those. But one change that they forced into the bill was that if you have a disqualifying conviction, which in this case would be the simple misdemeanor or a DWI, there's a lot of sort of things that would make people question how this is fair. But if you have any of those things that are defined as violent, then that disqualifies you from expunging any adult convictions under the statute. Now, that prohibition and disqualification does not account for the raise the age stuff we were talking about before. It doesn't matter what other sort of convictions you have there, but for adult convictions, it would be disqualifying.
And that was my next question. If one of my convictions was for, say, a DWI, I'm prevented from getting the other 2 expunged.
Yes.
Yes.
Okay, so we have one more example. I have 2 felony convictions. They're eligible. And now I have 6 misdemeanor convictions. Last conviction was in 2005. I finished my probation in 2007. What can I get it expunged, and when can I get it expunged?
You would take this one, DJ?
So are the felony convictions in the same session of court as
They are not in the same session of court, but they are Class H.
Class H felonies? And they're eligible for expunction?
Yes.
Okay.
They were first. So I had my 2 felonies.
Yep.
Then I had a number of misdemeanors afterward.
Afterwards, gotcha. I think that, and the 6 misdemeanor convictions are eligible. They're not violent.
They are eligible, yes.
Okay. So the 2 convictions, I think we'll cover that in the single felony conviction, whether or not those are expungible. Sounds like they are not, because that person is going to have multiple felony convictions from multiple sessions of court. So those felonies are not going to be eligible for expunction. In terms of the expunction of the misdemeanor convictions, yes, they didn't occur during that 7-year wait period. And so they meet that criteria, and they're not considered violent, so they wouldn't be a prohibition. The felonies are unfortunately not eligible, but the convictions, it sounds like they would meet that criteria.
Yeah, and exactly.
Okay.
Can I change that up just one little bit to say, like, let's just say the 2 felonies did occur, were disposed in the same session of court. You could actually expunge all of those. I mean, that is the one way that this was sort of expanded for people with nonviolent felonies, that they still kept it where you couldn't sort of go to multiple felonies being expunged in different sessions of court, or that were disposed in different sessions of court. I will say that is a version the Senate passed, but again, the DA stopped it from happening, but still something we're trying to push for. But the way that it was expanded is that now, before you could only have 1 felony, and if you had a separate misdemeanor, that would disqualify. That's not what's happening. That you could have the misdemeanors and the felony, and as long as the 2 or 3 felonies occur in the same session of court, you could expunge all of those if they're otherwise eligible. Now, and you can also, one other thing we changed with the law is it says that you can't get a prior expunction only disqualifies you from this relief if, and I have to get this right, if the date of the expunction precedes the date of the offense for which you're trying to expunge the second time around. So you could have, as long as you have all these things in the past and you start getting expunctions, you can go to one county, go to another, and sort of take your time, and you shouldn't run into the issues that we've run into in the past, where even in those situations where somebody has multiple, I mean, it's so rare that it rarely comes up, and mainly with dismissals, but you don't have to simultaneously file in the same place or deal with any of those issues.
Okay. So let's move on to the expunction of a single felony conviction. Who wants to take that on?
Well, we mainly covered it there. I mean, the same thing is that it's the same criteria as far as nonviolent. They didn't change that. I will say that, DJ mentioned more of the more understandable definitions, even though sometimes they defy common sense, of violent versus nonviolent. But there are other ones that don't make a lot of sense. Like, for example, they exempted any felony or any misdemeanor nonviolent from being considered nonviolent that involved methamphetamines, heroin, or possession with intent to sell cocaine. And so that is I think there'll be a chance to look at that in the future to start, eliminating those disqualifiers. But that is, so if somebody says I have a Class H felony that's a drug conviction, you're going to have to look at exactly what that drug conviction is to determine whether they're eligible. Right. And that's still going to be the case, and has been the case. The only other way that it was expanded slightly was it used to be, and you'd have to really know sort of expunction law to know this, but it used to be that not only to expunge multiple nonviolent felonies that occurred and that were disposed in the same session of court, not only do they have to be in the same session of court, but you couldn't have been arrested for one of those before you committed the second one, and that would be sort of disqualifying, and because they wouldn't count it as a, even if it was disposed in the same session of court, they wouldn't count as a single incident. We got rid of that other criteria. So now the only question is not when was somebody arrested or did they commit the crime, but were these multiple felonies disposed in the same session of court? And if yes, then they're treated as one felony and can be expunged. And as we talked about before, can possibly be expunged in unison with otherwise eligible misdemeanors.
Mhm.
But the wait period is 10 years, and the same sort of period that we talked about with the 7 years is that it starts after the date of sentence completion. So I will say that talking about one way the law got worse, potentially, it is that way. Though I've been reminded that not everybody was applying the same sort of interpretation of the wait period and when it begins, but there was an interpretation that said you only had to wait 10 years past the date of conviction to expunge a first-time felony. They've made it clear with this language that that is not the case, that it is 10 years past the sentence completion.
Okay, just to get back into some concrete scenarios. I have 3 misdemeanor convictions in early 2000 and they're all eligible. I have 1 felony conviction. When can I get the felony conviction expunged?
When was the felony?
2008. It's been 10 years since I finished probation.
As long as the misdemeanors occurred prior to the felony conviction and not during the 10-year waiting period, it sounds like the 10-year waiting period has been met. And as long as none of the misdemeanors were violent, the individual should be eligible to file for that expunction.
And
after the felony, go ahead, Daniel.
Well, one thing to note there is, let's say you have the felony, and then in that 10-year period, you have the misdemeanors. It's not that you'll never be eligible to expunge that felony. It's just that you have to wait 10 years from your last conviction. Like, you can't have any convictions during that wait period. So, if you were trying to expunge that felony, you would have to wait until 10 years after the misdemeanor conviction that occurred 2 years after your felony. And so I just want to make that clear. It just extends the wait period. It doesn't disqualify you in those sort of situations.
Yep, it just moves the wait period. That's correct.
Okay, so I have the 3 misdemeanors. I have the felony. I can get the felony expunged 10 years after I finish probation, parole. And after the felony expunged, I can go back and expunge the 3 misdemeanors. Did I get that order right? I think I did, yes. 3 misdemeanors, then the felony. I get rid of the felony 10 years later. What happens to my misdemeanors? That might be a better way to ask the question.
If they're eligible misdemeanors?
They are eligible misdemeanors.
Yeah, they are eligible to be expunged as well under the multiple misdemeanor expansion of the law.
Now, one of those misdemeanors was a simple assault, and later I have an eligible felony conviction. What can I do?
Unfortunately, that's considered violent. That's considered a violent offense, and so it would mean that you're not eligible to expunge that felony conviction because you have a violent misdemeanor conviction offense.
Now, is there a fee to file for these petitions?
Yes, there's a $175 filing fee, but again, just like the other scenarios, it's waivable if you're unable to advance that cost. Okay.
Now let's give a quick mention as to who has access to these expunged files.
So district attorneys would still have access to these files. That was a change that was made in 2017. And so, but what was expanded here is how they can use those files. And so basically, the line that we tried to walk here was that we're not trying to protect people from the subsequent or the consequences of subsequent criminal justice involvement with an expunction. What we're trying to do is protect them from the economic and housing consequences. And so basically, even if you get a conviction expunged, or if you have like a dismissed charge that was part of a diversionary program expunged, it will still, the DA will be able to look at it when they're looking at habitualization for a subsequent offense, your prior record level, sort of those punishment levels, but also rules of evidence, Rule 404. They can use it there. It's an exception. And the other exception is, for 9096 eligibility, right? Like, so you get a 9096 for a drug offense, you have that dismissed, you expunge it, the DA would be able to say, you get charged with another drug offense, they'd be able to say, no, we're not going to put you into the 9096 program or diversionary because you already had one. So basically, that's where it all is. But and law enforcement does not need to expunge their arrest records, or their investigation records for these expunctions. But it's still, the value of an expunction is much better in North Carolina than virtually any other state, because besides the exceptions that I just shared, the other exceptions are very rare.
And the reality is, I think that if somebody is seeking those expunctions and they are looking to put their past behind them, as it were, and they're starting that, they are looking for that fair chance or that second chance, those exceptions that Daniel just described are in most cases not even going to be relevant to that person, because they are not going to find themselves back in court for a criminal matter, or some of those other exceptions just aren't going to be relevant to them anymore. So I think it's a fairly fair balance, a compromise, because that's what it had to be.
Thank you both for that. And DJ, I know you wanted to talk about limited driving privileges.
Yes, this is just very quick, and I think I'm not trying to steal the thunder from the Justice Center and their partners, but because we do driver's license restoration, and we're always excited about opportunities to expand the ability for folks to legally drive, I think it is worth mentioning a new change for an additional limited driving privilege. And this was just signed into law, I think, July 1st. Again, big credit to the Justice Center and their partners for pushing this through and working with their North Carolina legislative points of contact and colleagues. But basically, as it stands right now, a lot of folks in North Carolina have their driver's license or their driving privilege suspended because of a failure to comply, an FTC. So they, went to court for a traffic matter. Maybe they pled guilty or pled responsible, and they were assessed some amount of court costs or fees or fines. Well, if they don't pay that money within a certain period of time, then the DMV will go ahead and suspend that driving license or that driving privilege, whatever the case may be. And it remains suspended until those monies are resolved or a court makes a determination to remit them. And so that has been a hugely negative factor for many, many North Carolinians in terms of getting their license restored, because it can be very costly, and frankly, some of the fees and fines that are issued by the court are just, disproportionately high relative to some folks' income, right? And so up until now, those individuals had to deal with those particular suspensions on a case-by-case basis. Now there's going to be, effective December 1st, a limited driving privilege, which is not issued by the DMV, but is essentially an order issued by a judge in the court where that person resides, so in the county where that individual resides, where they will petition that court for a limited driving privilege. And it will allow that individual to legally drive for the purposes that are laid out in that driving privilege. And it will allow them to access that if their license is suspended for FTCs. Now, it's limited to FTCs. So in other words, the individual can't have their driving privilege or their driver's license suspended for other reasons. But if the only cause of somebody's suspension are those unpaid fees or fines, which is a lot of North Carolinians, and disproportionately are Black and brown brothers and sisters, then they will be able to get that limited driving privilege and legally drive. And where I think that's going to be transformative is it will allow folks to legally drive to and from work which hopefully will expand employment opportunities, which then theoretically may allow somebody to go and deal with those suspensions and work towards getting the restoration of their full driver's license, which I think we can all agree is a really fantastic goal. So I just really wanted to let folks know about that because it's really exciting from our standpoint. And again, I think the Justice Center and Daniel and his colleagues, they really are owed a great debt of gratitude for that.
That is exciting. I can see why you were so eager to talk about it. That's all that we have today.
Ayana, can I interrupt real quick? Daniel, is there anything you wanted to add about that?
Only that it was the most undemocratic legislative process you could ever imagine. It was a provision that was dropped into a conference committee report at like midnight on the last day of the court session. So, 99 times out of 100 that burns the progressive cause these days. But in this one situation, it was helpful. So I give a lot of credit to Representative Batch, Representative Reeves, and Representative Lewis.
That's excellent. Thank you both for taking your time today. Thank you both for talking about the Second Chance Act. For anyone who has questions, please reach out to Legal Aid. We can be reached at 866-219-5262, extensions 1123. Figure I'd give the extensions and save some time. You can also reach us on the website, Legal Aid NC. That's all I have for today. Thank you, guys.
Thank you, Ayana. Thank you, Daniel.